Hamza, Richard is of the view that this whole process is unpatriotic and is a bad precedent. And if we encourage it, other Chief Justices may suffer same.
Good morning to Richard and my senior at the bar, and of course to your very good self and our cherished viewers out there and listeners out there. Sammy, I think that it is important to situate today's discussion. I have listened to Richard, and this is not my first time of listening to him on this matter, and that of the New Patriotic Party. And I am struggling to understand what they truly stand for as a political party in this particular matter. You see, this might appear historic, but when it comes to the application of Article 146 of the 1992 Constitution, this is not the first time it has been invoked. And my senior Apia Dankwa would agree with me that those who attempted to use it on the pillars of our democracy for the first time was the New Patriotic Party. Indeed, it was Richard Nyama and Honorable Arnold Dampre who first petitioned President John Dramani Mahama using Article 146 for the removal of Mrs. Loretta Lamte as Commissioner of the Commission on Human Rights and Administrative Justice, Shiraj. At the time they were doing so, didn't they know the implications such an action would eventually have on other institutions of state? That falls clearly under Article 146. Didn't they know as a political party? Were they subjecting our democracy to danger? They did not stop there. They proceeded to invoke same Article 146 and demanded the removal from office of Mrs. Charlotte Osei. She was taken through the processes and removed in a similar fashion by His Excellency Nana Addo Dankwa Akufo-Addo's regime, of which my brother, as Director of Communications of the NPP, spoke in defense of. At the time he was speaking, defending the Charlotte Osei removal process, didn't he know that such an action could pose a serious danger to our democratic stability, especially when the Electoral Commission of our republic is actually the anchor of the four pillars of government, if you like, that is adding the media as the fourth estate. Because without a credible Electoral Commission, you cannot realize the dreams of our democracy, because you would not be able to elect an executive, you would not be able to elect the legislature, and you would not be able to have in place a working judiciary. So that tells you the importance of Electoral Commission and the commissioners when it comes to the stability of our democracy. Didn't my brother in the NPP know that? But I believe they argued forcefully that they were acting in tandem with the dictates of Article 146. Remember, that was when that popular phrase that the president is acting as a conveyor belt came in. So what has changed? Why these double standards? Even when we're pointing to apparent breaches of the process, they told us to shut up. And mind you, it was not the National Democratic Congress alone that rose against that action. Today, in the case of the Chief Justice, it is the NPP that is leading the charge. They are those making the noise. Who else is speaking? So they think that their views on this matter supersedes that of every legitimate Ghanaian out there. These are the questions we should be asking, Sammy. And for us, look, they must thank God that His Excellency President John Dramani Mahama is president today and does not have an iota of the character trait of His Excellency Nana Addo Dankwa Akufo-Addo. The same President Mahama, in his first term, we had petitions filed against the then Chief Justice, Madam Georgina Woods, to the extent that a former retired Supreme Court judge, Justice Pega, filed a petition for her removal. We know how the MDC suffered in the hands of Madam Georgina Woods. Indeed, it was under her that one of our leading members, most celebrated, revered in the politics of the NDC, and to a very large extent, our national political space, the revered Chachu Chikata, was incarcerated. And remember the injustice that characterized his incarceration. So the NDC was a wounded party in opposition, and many of our supporters called for the removal of the Chief Justice. It was the most painful experience since 1992 for the National Democratic Congress. But even with that, when President Mahama eventually received a petition, not just from any ordinary Ghanaian, but even a member of the bench, Justice Pega, President Mahama looked at the petition in consultation with the Council of State and declared that those petitions did not have merit and threw it out. So if today you have the same President John Dramani Mahama, who has received petitions, not one, not two, about 3 or 4, from well-meaning Ghanaians, demanding the removal of the current Chief Justice, now suspended. And the same president proceeds on the basis of that to, in consultation with the Council of State, to institute, to find a prima facie determination and say we should proceed.
The argument is that these petitions are not, the substance in these petitions are not really anything.
You see, it is not, the Constitution did not say that myself and you should determine the substance or otherwise of those petitions.
But sometimes you need to consider the kind of misconduct or allegations
you see, that is
before you can take a course of action.
But you see, that is not for you to make. It is for His Excellency the President in consultation with the Council of State. So you want us to sit in this chair and pretend that the President in consultation with the Council of State, we are not dealing with one member of the Council of State. Collectively, we are smarter than them. And that looking at the petitions, we cannot see grounds for the establishment of a prima facie case. And so the fact that they have seen it means they are wrong. We are that brighter than them. Is that the conclusion on this table? Do we know what facts are available to the President and to the Council of State because of their privileged position? And how they can quickly, based on what you deem as mere allegations, because remember the Constitution says that it must be in camera, the process must be protected. Based on what you call as what you call mere allegations, do you know that maybe the Presidency in consultation with the Council of State have looked at it, decided to dig a little bit further to see whether some of them have substance? That's the essence of prima facie determination. You are not privileged to have that information. You don't have that luxury of state authority. They do. And they have come to such a conclusion. And you say that on the basis of the fact that these are mere allegations, it is not enough to establish a prima facie determination. Some I disagree. Again, when it comes to the delivery of justice, there is nothing like mere, because the lives of everyday Ghanaian depends on it. And I had cause to make the same point some weeks ago on this same platform, that allegations that might not be sufficient to remove you, Sammy, from hosting this program. When it comes to our justice delivery system, because of how sensitive it is, might be enough to remove a Chief Justice. Because we cannot gamble with our judiciary. So what do you consider mere that you can get away from as the host of this program might be the basis of taking out a Chief Justice? Because if we make the mistake and brand it as mere, it could lead to somebody being denied of his personal freedoms because of that mere allegation. That is why we cannot take it lightly. So these are the facts. President John Dramani Mahama has done absolutely nothing wrong as far as these processes are concerned. And I am yet to hear even the NPP point out what they consider a breach of our Constitution as far as the President's actions are concerned. They have not been able to point out one. what they have been engaged in the words of the former, the suspended Chief Justice, is to blah, blah noise out of their system without any substantial basis of engagement when it comes to the legalities. These are the facts. Now, to the press conference of the suspended Chief Justice. Sammy, that is another interesting one. First of all, I think that Madam Araba Tokono.
In 5 minutes.
Oh, but that is the meat of the discussion.
In 5 minutes. You had enough time, but you were having a preamble before.
To him, I beg you, Sammy. No, 5 minutes will not be fair enough. You see, because this is the essence of, you see, listening to her. For the first time, I came to the conclusion that she had taken a conscious decision to go rogue as far as this matter is concerned. And in that action, she consciously chose to desecrate the Constitution of the Republic of Ghana, our judicial architecture, and finally, openly dared the presidency of the Republic of Ghana, which is also another constitutional creation. And I'll explain why. I say that he has desecrated the Constitution of the Republic of Ghana. You questioned the motive behind holding the proceedings in camera and proceeded on the basis of that to file an application at the Supreme Court demanding that the proceedings be made public. In addition to that, you requested that your human rights were under threat and being violated by the committee. That was what the supplementary affidavit sought to do, not so senior. Now, despite the fact that you are a judge of the Supreme Court and ought to know that there are a litany of cases that already laid down the rationale behind holding such proceedings in camera. You are at liberty to disagree and to call for the Supreme Court to have a review. You did so. The Supreme Court looked at your matter and decided that there was no constitutional basis for such a call, and you did not have that right, and threw you out. And they just didn't throw that out. They also proceeded to strike out your supplementary affidavit that pointed to human rights violations on the basis that entertaining it would constitute a breach of Article 146, Clause 8 of the 1992 Constitution that demanded that the process should be made in camera. This is the ruling of your colleagues. In her press conference. So the essence of the ruling was to protect the in-camera proceedings as enshrined in Article 1468. You hold a press conference and you proceed to discuss the petitions one after the other, the content, the very objective the Supreme Court ruling sought to prevent. You desecrated the bench that you were a member of. Again, you desecrated Article 1468 that demands that such proceedings be made in camera. So clearly, she went rogue, ready for all the consequences because she knew exactly what she was doing. So if this in its own does not constitute stated misbehavior, that is enough basis to remove a Chief Justice from office. What else would qualify as stated misbehavior? Senior counsel. A Chief Justice who ought to know better. And your justification was that the petitions are already in the media. Who leaked those petitions in the media in the first place? Because His Excellency President Mahama had cause in one of his correspondences to you to caution you not to leak documents because you have already leaked a letter meant for him to the media before it got to him. And truly, after he gave you the petitions, Assassin Radio, a radio station aligned to one of your lawyers because he's a leading member of the NPP, the former Attorney General, and the very person that they accused you of being in bed with at the time you were Chief Justice, who happens to be your defense attorney now. A leading radio station aligned to their party was the first to publish it on their website. The full contents of the petition and the full contents of her responses. Do we need an angel to descend from heavens and tell us who leaked those petitions to that radio station? That's one. So that is Madam Araba Tokono for you. And you proceed on the basis that these things are already out in the public domain to run commentary on it? Is that enough justification? Even after your colleagues on the bench cautioned against him and gave orders to that effect that it shouldn't be done, and our constitution under Article 1468 prevents same from being done. So this is a woman who has declared war, not just on the executive, but our constitution and her colleagues on the bench. It is clear. It should be clear to all of us. And Sammy, this cannot go lightly. Finally, because you are pushing me,
because I
can understand the discomfort. So, but
I discomfort in terms of,
like in terms of your timing, not in the moment. So, but you see, finally, Sammy, another point that needs to be made has to do with the rather unfortunate judicial review application that Madam Araba Tokono has filed. I remember on another sister station and on this very desk, when I saw her supplementary affidavit, senior, to the Supreme Court, I concluded, I was clear in my mind that these were human rights issues. And so I was of the view that the appropriate forum ought to have been the High Court. And I remember advising that they should have taken advantage of the judicial review provisions in our constitution and go to the High Court. That was better clothed with authority to handle that matter. And I was convinced, apart from her call for an interpretation of the in-camera proceedings, I was convinced that it was a human rights, holistically her case was a human rights challenge dressed in the form of interpretation to clothe the Supreme Court with the authority to intervene. But today, we are told by her that she has filed an application at the High Court. But you know what she has done to herself? Senior, you would appreciate this better. The Supreme Court, in its ruling, in her first application, decided to strike out the content of the supplementary affidavit on the basis that it will constitute an affront. Going into it would constitute an affront to Article 146, Clause 8 of the Constitution, which demands that the processes must be in camera. It will be a breach of that provision. Today, you have taken those same similar concerns. After your initial mistake led to the Supreme Court in that decision shutting the door on the High Court to act. Because if your application at the High Court now rests squarely on human rights violations, of which the Supreme Court in an earlier ruling had indicated that it cannot go to. So if the Supreme Court cannot go into it because of potential breaches with Article 1468, you think that the High Court will violate the orders of the Supreme Court to entertain it under its jurisdiction on the basis of human rights? The door is closed. So I am waiting to see the kind of miracle his attorneys would perform. And no doubt, many of them are brilliant lawyers. But the only reasoning behind such missteps clearly is politics. So they are not being driven at this stage by the law because they have succeeded in convincing the woman and themselves that the whole process is political. So they are missing the thorny legal issues they could have taken advantage of. And in the process, they are shutting the legal doors upon themselves.
Okay.
So it has nothing to do with His Excellency President John Dramani Mahama. It has nothing to do with the National Democratic Congress as a party. It is Madam Araba Tokono's cross. And she must stand tall and face the committee. After the committee is done with their work, and she feels strongly about the outcome of the recommendations of the committee, I think that would be the opportune time to take advantage of the power of judicial review given to the High Court.
Thank you very much. Hamza Suhuyini is a member of the NDC communications team.